What does it mean if I have an excluded lease? In most commercial leases, you may notice a clause exclusion of Section 24 to Section 28 of the Landlord and Tenant Act, 1954. This means that you, as a tenant, do not have the automatic right to renew your lease when it expires. It is also known as an excluded lease. Key things to note on an excluded lease: no automatic right to renew. Some business tenants have the statutory right to renew their lease when it expired, unless the landlord has valid grounds to oppose the renewal. If your lease is excluded, you will not have this right. Once your lease term ends, the landlord has the right to repossess the property without offering you a new lease. Number 2, no security of tenure. The exclusion removes the security of tenure. Your right to remain at the property and to negotiate a new lease after the expiration of your lease term is not protected by law. At the end of the lease term, the landlord is not obliged to offer a renewal, and you must vacate the premises if the landlord chooses not to renew the lease. Why would the landlord want to exclude the Landlord and Tenant Act 1954? Unfortunately, it is the decision of the landlord whether or not to grant you a right to renew or security of tenure. However, the exclusion may provide more flexibility for the landlord and allow them to regain possession of the property more easily at the end of the term. If the lease is excluded, they are not required to justify the reasoning to refuse a lease renewal, unlike in a non-excluded lease where specific grounds must be met. In addition, short-term business leases will usually be an example of an excluded lease, as long-term security is not a priority for either party. If you have any further questions, please do reach out to Lisa's Law Solicitors. Don't forget to subscribe to our YouTube channel.